Hello, welcome to Bear Paw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bear Paw Media and Education is a Department of Native Counseling Services of Alberta, and our primary goals are to make public legal education accessible, understandable, and affordable for Indigenous people. We at Bear Paw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities and is always edited by lawyers. Of course, laws change with elections and societal values, so this information is designed to be general in nature and may not apply to your specific situation. It may still be necessary to consult a lawyer for legal advice to assist you. For more information, you can go to our website at bearpawlegalresources.ca or follow us on social media at Bear Paw Legal. I'd like to begin by acknowledging that the land in which we gather is Treaty 6 territory and the traditional meeting ground and home for many Indigenous people, including the Cree, Saulteaux, Blackfoot, Métis, and Nakota Sioux. Today's topic is going to be traffic and bylaw violations with Bill 9, which is the enforcement of minor provincial offenses. I'd like to start with a video created by Bear Paw Media.
Many Aboriginal men and women have suffered the sordid shame of receiving traffic violations. What is a traffic violation? It is any breach in traffic law that ends up impacting the public safety and your wallet. It results in the nagging feeling that you should have not done the thing that you did.
Where am I going to get the money to pay for this? No Xbox this year.
Hello, I'm TV's Mina Moses, and tonight we'll be talking about traffic violations and breaches and the fines that follow. And as the kids say, we'll be keeping it real. Let me introduce you to Marcus and Caden. Now, Caden is a perfectly normal type of person. He respects his elders, has a girlfriend, loves nature, but when it comes to the everyday business of driving and the law, these men have numerous difficulties and 3 traffic violations in the past 2 years. 3 violations in the past 2 years? Why?
Wow, things just happen.
Can you tell me about the first one?
Sure. I was sitting at home with Marcus and he says,
Ticke and dying for $7.99.
$7.99? I have $7.50.
$7.50? $7.99.
Well, maybe they'll cut us a deal.
We could go without cheese. Let's drive.
Guy, I don't have my insurance or registration.
What happened next?
Marcus is always talking about Aboriginal rights and the law, and he says,
Dude, this is our land. We don't need insurance or registration. We're sovereign.
Are you sure?
I'm pretty sure. Does this face look like I'm messing with you? We could do it.
Let's drive.
Yes.
So, against your better judgment, you decided to go.
Marcus is so smooth and his delivery is spot on.
Sounds like a pickup to me.
Tell me about it. I was driving on the road to Big Sky Pizza when... Oh my.
Don't worry about it, bro. I'll take care of this.
Hi there. Do you know why you're being stopped today?
Maybe.
I noticed that your license plate is expired. I need to see your valid driver's license, your registration, and your insurance.
We're gonna have a problem there, officer.
This is our land. We don't need insurance or registration just to go to Big Sky Pizza.
Come on, guys, you know the rules. You need to have valid registration, insurance, and driver's license. I need to see your papers, please. Just wait right here. Okay, I'll be right back.
Should you have insurance on the reservation or settlement? Take our poll now. Call 1-800-328-3425. Call takers are standing by. Certain charges may apply. Was the fine considerable?
Considerable. The fine for no registration is $230. Failure to produce documents is $172. And the fine for not having insurance is $2,875. Total, $3,335. You know what that means? No Xbox. A day in court and failure to show up, 60 days in the can.
Anything else?
Yeah. 150 for towing and impound charges. My 89 Ford F-150 is only worth 400.
Well, two can dine for $3,399.
Thanks, Mr. Lawyer.
Or we could walk for free.
We now turn our attention to Marcus and his sordid traffic tale.
I thought I was in the right.
Can you explain?
Sure. I was cruising down the highway. It was a 100-kilometer-an-hour zone, and there was an old driver dude who was going 95. So I thought it was legal. I accelerated to 110 to clearly pass him. And right there, busted. I didn't even see him.
Hello again, Marcus.
Hello, sir.
Do you know why I stopped you this time?
A quota? Sorry. I was just behind this really old, slow driver.
Okay, Marcus, there are no provisions for speeding. The speed limit is 100. You know the rules. Okay, I'll be right back.
What were your fines? Did you receive demerits?
Okay, 15 kilometers over the speed limit. $115 fine, plus I lost 2 demerits. And if I add those 2 to the other 2 from before, just for making a U-turn, my insurance goes up about 25%.
Are you helping Caden with his fine?
Well, I'm helping fix his fence. And I'm also helping him fix his septic field. Woo-wee!
Traffic violations affect all of us, and as Aboriginal drivers even more so. Fines and demerits cost money and take money from you, your family, and your friends. And in certain cases, if you do not have the ability to pay, there is the possibility of jail time. A review of the new demerit and fine system could save you a lot of money and lost time. And being Aboriginal and driving on the reserve or settlement does not grant you any special rights under the law, no matter what your friends may say.
When we come back, courts, fines, demerits, and misdemeanors.
Courts, fines, demerits, and shame. These are all consequences we pay for our actions. These penalties are not to be feared, but respected, and dealt with promptly. When is your court date, and will you attend?
The court date is in a month. I owe $3,000, and I'm not sure I can pay. So I don't think I'm gonna attend. I'm scared to go to jail.
Are you aware of all the options, both good and bad?
Yeah.
There are a number of options available for those who cannot afford it. For legal representation, you could see legal aid, student legal services, student legal assistance in Calgary, and Native Counseling Services of Alberta. In order to help Caden make up his mind, we will visit the offices of NCSA and speak with one of their court workers. What should someone like Caden do?
The first thing Caden should do is he should seek legal representation, which can mean legal aid, student legal services, or even Native Counseling Service. He should show up on time the morning of his court date, because failure to do so could result in a conviction in absence or a warrant.
Hey! We could go to this house, or we could go to the big house.
There's been a number of occasions I've seen where people haven't shown up to court and they get extra fines, or they get a warrant issued for them, or they can't even register their car in the future.
But in Caden's case, it seems to be cut and dried.
Well, I haven't seen too many cases that are completely cut and dry. As long as he appears in court, the judge could take mercy on him.
Are fines fair? Send your comments to poll@bearpawmedia.ca. Do you have any other advice for Caden?
Yeah, there's a pretty simple process that he should follow that would save him some grief in the future. He should get his facts straight before he forgets what happens the date of the offense. That can mean what time it was at, the weather conditions, if there are any witnesses. And he can also decide to get legal representation in the future and give them these facts so that they can build a case together. But Caden has to remember to show up to court, because if he doesn't, he has no more options. And even when a judge decides to give him his sentence, he could take leniency on him. That could be where Caden works, if Caden has a family, if there's any children involved. All of that is factored into the judge's decision.
What are the benefits of going to court?
That's a good question. 90% of the time you can get your fine reduced. All you have to do is speak to the Crown prosecutor, plead guilty to the fine, and it will be lowered for you.
One of Caden's concerns is he does not have the money to pay the fine. That is causing him some doubt as to whether he should attend.
It's a pretty common complaint in this line of work. There's actually a lot of options available to him. One is the Fine Option Program, where you would work time volunteering at, say, the Bissell Center, Mustard Seed Church, or any rec center, anything around your house.
Come on, don't be like that. Think of all the on-the-job training that we're getting.
And what happens there is your hours are translated into money, which in turn go towards your fine.
Hey, at least we're not doing time.
Dude, this is time.
Well, we're trading time for money.
3 more months.
If you don't have money, but you will probably be getting in the future, you can get a fine extension, which is anywhere from a month to a year, where you can pay the fine off every month or every week, however you see fit. And also, if Caden's working during the week, he can serve his time on the weekends, which frees him up to continue his life. But once again, not showing up for court eliminates these options.
The failure to attend court cases, is it quite common?
You'd be surprised how common it is, actually. I'd say about 40 to 60% of my clients don't show up on the days of their court. I'm not sure if they're afraid of what could happen or if they simply don't understand. You can get a warrant issued, or you can even be convicted in absence. But all of this is avoided if you show up for court. And if you feel that you can't, you can have a legal representative stand in for you.
Did the advice of the court worker help?
Yes. My first instinct was to run and hide, but I'm going to attend my court case and find a legal rep.
Not all court cases are extreme as Caden's. Marcus, for example, has a $115 fine and lost 2 demerits for driving 15 kilometers over the speed limit. Let's see how he handles the problem. Marcus, have you paid your fine yet? And do you know the penalties for not doing so? Do you know what may happen if you receive a 3rd ticket?
No, I never really gave it much thought. I mean, I'm a little strapped for cash, and so I might not be able to pay for it. And if I stay at Johnny Jack's cabin, they won't be able to find me there.
In the case of Marcus, the province can add an additional 20% to your fines if you do not pay on time. Also, you cannot renew your plates or registration. Plus, an accumulation of $500 or 5 or more tickets could result in a suspension of your driver's license. And lastly, the insurance companies could add an additional 25% to your premiums. So it's always smarter to pay your fines on time.
Have you learned anything from this at all?
Yes. You know, going to court and thinking about all those traffic tickets isn't the kind of stuff I like to think a lot about or do research on. But a little info seems to stop a lot of grief.
In conclusion, review the Traffic Act from time to time. Seek counsel for major tickets or violations. Pay your tickets on time. It will save you and your family money, time, and woe. Yes, a little knowledge stops a lot of grief.
Next week on Bear Paw TV, headlighting and haunting. What are your options?
All right, so I hope you enjoyed that video as much as I did. And so let's continue on with our presentation. There is a myth out there, not so much or not so popular today as it has been in the past. However, there was some basis for this some basis for this myth. And the myth is that traffic laws don't apply on reserve because that is classified as private property. In 1977, Regina versus Big Eagle, Mr. Big Eagle was charged with driving while disqualified. His defense was that he was driving on reserve land, which is private, not public land. Further, not only are roads on a reserve not public roads, but also members of the public can be charged with trespassing for entering the reserve by virtue of the Indian Act. Mr. Big Eagle was acquitted. 1978, the Supreme Court of Canada, the Big Eagle decision was overturned, stating that a road includes any roadway, driveway, street, land, or other place open to the public for the passage of vehicles, and the driver of any vehicle shall comply with all laws and regulations in force from time to time in the province in which the reserve is situated relating to motor vehicles, except such laws or regulations as are inconsistent with these regulations. In no sense can roads on the reserve used in common with other residents be considered the private domain of the resident. These regulations apply on all roads, even within First Nation reserves. In the Traffic Safety Act regulations, road includes any roadway, driveway, street, land, or other place open to the public. And so, yes, for a brief shining moment in 1977, traffic safety laws were not applicable on reserve because the Indian Act stated that it is private land. However, the Supreme Court of Canada in 1978 overturned that decision based on public safety. And so any road or land used by the public, drivers must comply with the traffic safety laws. So then, what's the difference between a Part 2 and Part 3 ticket? As a court worker, I would sometimes see people getting Part 2 tickets, which require that people attend court. And because it's in ticket form, sometimes people don't understand the difference between Part 2 and Part 3, wouldn't show up for court, and a warrant would be issued. Whoops. If you are charged with a provincial offense, the peace officer will give you one of the following documents: either a violation ticket, a summons to a person charged with an offense, so a summons or an appearance notice. Unless you are otherwise directed, all your court appearances will be at the court location indicated on the violation ticket. You should also direct any correspondence or telephone calls to that specific court location. It's very important that you carefully read the front and back of the ticket. If you're anything like me, you get a speeding ticket and the first thing you want to do is crumple it up and toss it. However, it's really important that you take a couple of minutes to read both front and back of the ticket to get all of the relevant information. In most cases, the peace officer will give you a violation ticket, which will tell you what you've been charged with, the date and time you're required to attend court, and the court's address. There are two types of violation tickets. Violation tickets that contain a summons violation ticket. Violation tickets that contain an offense notice, and each ticket type uses different court procedures. If the court appearance required box is checked, it'll be on the top of your ticket. You must appear in court in person or by agent on or before the date specified in the ticket. If you don't appear in court as required, a warrant for your arrest may be issued. Voluntary payment option box with the fine amount, if that's checked off, you have the option of paying the specified voluntary payment amount in full or appearing in court in person or by agent on or before the date set out in the ticket. By paying the voluntary payment amount, you are determined to have pled guilty to the charge. If you don't pay the voluntary payment amount and you don't appear in court when required to do so, a warrant for your arrest may be issued. Summons violation tickets will be pink with Part 2 summons in the upper right-hand corner. The officer may have marked the court appearance required box. Please make sure you check the top of your ticket to see if this court appearance required box has been checked off. The officer may have marked the voluntary payment option box with a fine amount. So just make sure that you check your ticket to see which of these have been checked off. An offense notice violation ticket will be yellow or white. And they're Part 3 offense notices, which will be checked off in the upper right-hand corner. Remember, it's very important that you read both sides of this ticket carefully. 5 ways that a license can be suspended. Driver has been found guilty of driving while under the influence of drugs or alcohol. And we have a whole workshop on DUIs. And so if you want to know more about the laws around impaired driving, which have gone through some very significant changes in the last few years, check that workshop out. We also have a great video on that as well. If the driver has violated another criminal code section dealing with driving, such as criminal negligence causing bodily harm or death, dangerous driving, or flight from the police, the license could be suspended. Under Section 86 of the TSA, the Traffic Safety Act, the court may suspend a driver's license for up to 3 months if the driver fails to fulfill his or her duties resulting from an accident. So if you fail to remain at the scene of a crime, etc. If you fail to follow certain rules of the road or drive carelessly or violate a municipal bylaw which regulates moving vehicles or violates a regulation in the National Parks Act, then the courts have the ability to suspend licenses as well. Failing to pay outstanding fines or motor vehicle judgments may also result in license suspensions, and as well, maintenance arrears. In addition to any penalties under the Criminal Code of Canada, the province of Alberta will suspend your license. The province will also set conditions for you to get it back. The Alberta suspension is served at the same time as a court-ordered driving prohibition. For example, the court gives you a 3-month suspension. The Alberta suspension is for 1 year. After 3 months, the court-ordered driving prohibition would be over, but you would still have 9 months left on your Alberta suspension. Alberta has enforcement programs to catch people who ignore the law and drive while their license is suspended. All provincial law enforcement agencies work together as a part of the program. If you're caught driving a motor vehicle while your license is suspended, you may go to jail. Jail terms for this offense are common. You will also face a large fine. In addition, your license will be suspended for another 6 months or more. This new suspension won't start until any existing suspensions end. The vehicle you're driving, whether you own it or not, will be seized and impounded. All towing and impound fees will be charged to the registered owner of the vehicle. So I hope that wasn't your mom and dad's vehicle you were driving or your spouse. Make sure to keep your documents current. If you are caught driving without a valid driver's license, you could be fined $270 or $203 or $405. And these fines may have gone up even. Driving without valid registration, again, a fairly significant fine. If you are driving without a valid license plate, you can be fined. Driving without valid insurance. And this is a huge fine. For the first offense of driving without a valid insurance, between $2,500 and $10,000 fine plus a 15% victim surcharge. And in lieu of the fine, you could be facing between 45 days and 6 months in jail. And for each subsequent offense within 5 years, that fine goes up between $5,000 and $20,000 plus the 15% victim surcharge fine. Seriously, if I ever got caught with this and charged, I would have to be serving time, because I don't know about you, but I don't have a spare $10,000 or $20,000 to spend on a fine. So it's just better to make sure that you keep your documents current and make sure that you always have valid insurance and registration. The Alberta Transportation Safety Board also has the power to suspend an Alberta driver's license if they think it's necessary for such reasons as poor driving record or medical grounds. In making its decision, the board considers a number of things, including a person's driving record, attitude, skills, knowledge, etc. You can always appeal the decisions directly to the board, but your license remains suspended until you have confirmed with the board that your license has been reinstated. According to the law in Alberta, the driver must make sure passengers under 16 years of age are buckled up correctly. For children under 40 pounds or 18 kilograms, or under 6 years of age, the law says an appropriate child safety seat must be used, the child safety seat must be correctly installed in the vehicle, and the child must be properly secured into that seat. Using a car seat properly will reduce the likelihood of a child being injured or killed in a crash by as much as 71%. The fine for not wearing a seat belt or having a child properly restrained is, well, it was $155. I believe it's now $287. Fines continue to go up every year. There's no current law in Alberta that mandates the use of booster seat. However, the Government of Alberta safety experts and best practices recommends that once a child graduates from a child safety seat, that the child be in a booster seat until they turn 9 years of age or reach a weight of 80 pounds or 37 kilograms. Booster seats help position the seat belt properly on a child's body. The shoulder belt should lie across the middle of the child's chest, and the lap portion of the belt should touch the hips. As of September 1st, 2011, Alberta has brought in distracted driving legislation. And so specifically, what is included in the distracted driving legislation are that it restricts drivers from using handheld cell phones, not able to text or email, or using electronic devices, or entering information on GPS units, or reading printed materials in the vehicle, writing, printing, or sketching, personal grooming, as well as pet involvement. For both the safety of pets and road users, it's best if pets are secured in an appropriate pet carrier. Complements the current driving without due care and attention legislation. Texting and emailing applies to all vehicles as defined by the Traffic Safety Act, including bicycles. Entering information on GPS units. It applies to all roads in both urban and rural areas of the province. Again, it's about any roads or lands that are used by the public. And initially, the fine for this offense was $172. It's now gone up to $287, and it did initially say no demerits, but there is now demerits as well for distracted driving. Allowed activities. Using a cell phone in hands-free mode, most new vehicles now have hands-free Bluetooth technology. Using an earphone in hands-free or voice-activated mode. If you're drinking a beverage such as a coffee, water, or pop, eating a snack. So this would be like a chocolate bar or something that doesn't require both hands or too much involved attention away from your driving. Smoking is also allowed unless you have a minor in the vehicle, and then it's definitely discouraged. Talking with passengers is allowed. Listening to a portable audio player, and also calling emergency services such as 911 with a handheld cell phone. In Alberta, we also have the Graduated Driver's License Program. So all new drivers are subject to the Graduated Driver's License Program, GDL, and the stages and conditions for GDL are the Class 7 Learner's Permit. New drivers must be 14 years of age or older. They must pass a vision screening test, pass a knowledge test on the rules of road, and have parental consent if they're 17 years of age or under. Conditions for drivers in the learner stage. They must hold a Class 7 license for at least 1 year to be eligible to move to Stage 2. They must be accompanied by a fully licensed, non-probationary driver who is 18 years of age or older and is seated next to the driver. They're not permitted to drive between midnight and 5 a.m. They may not have more passengers than the number of seat belts in the vehicle. Will have your operator's license suspended at 8 demerits. And there is a 0 alcohol tolerance. So Stage 2, to become a probationary driver, you must be at least 16 years or older. You must pass the basic Alberta road test. You must have held a learner's permit for at least 1 year as well. And the conditions for drivers in the probationary stage. You must spend a minimum of 2 years as a probationary driver to be eligible to move to Stage 3. You may not have more passengers than the number of seat belts in the vehicle. You will have your operator's license suspended at 8 demerits, not 15, but 8. You may not reclass to a commercial operator's license, and you may not serve as an accompanying driver to a learner. So when somebody is at the Stage 2, they're classified as a probationary driver, they cannot be the accompanying driver to someone who has a learner's permit. And again, There is the zero alcohol tolerance for new drivers. Drivers licensed under the graduated driver's license program are restricted from operating a vehicle when any amount of alcohol has been consumed. Violators will have their license suspended automatically for 1 month under the GDL Alberta Zero Alcohol Tolerance Program, AZAT. If a novice driver violates this condition a second time, they will once again be suspended for 1 month and will be required to appear before the Alberta Transportation Safety Board. Stage 3. To become a fully licensed Class 5 driver, you must not have had your operator's license suspended or canceled for the last 12 months of a 2-year probationary stage. So that means that you have to have had at least 12 months solid with no suspensions or infractions against you. Otherwise, your probationary license will continue to be extended. And you must also pass an advanced road test. So violations and penalties of the graduated driver's license program. If you have consumed any alcohol, there's an immediate 30-day license suspension. If you have more passengers than seat belts, a $100 fine and 2 demerits. If you are caught driving after midnight for Class 7, $100 fine and 2 demerits. No accompanying driver, again for Class 7, $200 fine and 2 demerits. As well, speeding tickets will also accumulate demerits. And remember that anybody that has a Class 7 or a probationary Class 5 only has a maximum of 8 demerits, and then their license is suspended, as opposed to the 15 demerits for a full Class 5 license. So then what happens if someone has been charged with an offense, a driving offense? The court process, the ticket, as I'd mentioned earlier, the date and time of your first court appearance will appear on the front of the violation ticket. You may appear in person or have a lawyer or agent appear on your behalf. You could also complete the mail-in option on an offense notice violation ticket. Just make sure that you give yourself enough advance time to for the ticket to reach the courts before your court date. You also have the right to ask for an interpreter. In Edmonton and Calgary, you attend the Justice of the Peace counter or the traffic court counter to enter your plea and set trial dates. Other locations may require you to go into the courtroom. The charge against you will be read out. You will be asked if you plead guilty or not guilty. You may ask to reserve your plea to get for further legal advice or to retain a lawyer. You will be given another date to return to court. Also, because of COVID, tickets are now being processed online as well. If you choose to plead guilty, before entering a guilty plea, find out the possible consequences of the conviction. Listen to the offense details that the traffic commissioner or Crown prosecutor reads to the judge to make sure they're correct. What is the maximum fine? Is there a possibility of being sent to jail? Is there a minimum fine? Will you get demerits? Will a conviction affect your insurance rates? Are there any consequences that you may be unaware of? You'll be asked if you agree to the facts. If you don't agree with something that is said, you will have a chance to tell the traffic commissioner, Crown prosecutor, why you disagree. You cannot plead guilty unless you agree that you committed the offense. If you disagree with many of the facts, you should plead not guilty. You can transfer or waive charges to another court location, but only if you intend to plead guilty. If you're planning on pleading not guilty, you will be advised of the date and the number of the courtroom where the trial will be heard. On court day, arrive at least 15 minutes early and let the Crown prosecutor know that you're there. Bring your witnesses to court. You can also subpoena them if necessary. Your witnesses must be physically present in court to testify. Letters or written statements from witnesses, even if sworn, will not be accepted as evidence. You can subpoena, which compels a witness to come to court if they're unwilling or if they need it to get time off work. You may pick up copies of subpoena forms at the clerk's office. Fill out one form for each witness and ask the clerk to have it authorized. Once this is completed, you must serve the witness with it. You could arrange for the police or a private document service company to serve it. There may be a fee for that service. So then what happens at trial? The Crown prosecutor calls and questions their witnesses. You will then have an opportunity to cross-examine the witnesses. The Crown prosecutor may then redirect follow-up questions of the witnesses. Now it's your turn to put forth a defense. After both sides have finished presenting their cases, the traffic commissioner or judge will ask for closing arguments. This is followed by sentencing. You and the Crown prosecutor may ask for an order for exclusion of witnesses so that all witnesses must leave the courtroom until called back in to testify. Listen to the witness testimonies. If there is something that you disagree with, you then can ask the witness questions about the testimony that you disagree with. The prosecutor may also have documents, photographs, or other items to show the traffic commissioner or judge. This could include things like a certificate of suspension or registration. The prosecution will ask the traffic commissioner to have the item introduced as an exhibit. These are admissible if they are relevant and properly identified. You don't have to put forth a defense. It's the Crown prosecutor's responsibility to prove your guilt beyond a doubt. If they fail to do that, then sometimes it's in your best interest to not add anything else. Further, if you decide to testify and you have a record of prior convictions for either provincial or criminal offenses, the prosecutor can ask you about your record. But if you don't give evidence, the prosecutor can only mention your record if and when the traffic commissioner or judge finds you guilty. During arguments, if you called witnesses, you will go first. Otherwise, the prosecutor will go first. Before being sentenced, so if you are found guilty, your sentence could include a monetary fine, probation, imprisonment, or a combination of those. You may be ordered to pay compensation for loss or damage to property suffered by a person as a result of the crime. However, before being sentenced, the traffic commissioner will ask you to provide information about yourself and your circumstances that might affect the sentence. Sentencing information would include your age, whether you're married, how many children you're supporting, your employment situation, income, health issues, and other potential barriers or obstacles. You may want to include your plans for the future, such as school, etc. You may need to request time to pay, depending on your circumstances. On rare occasions, the traffic commissioner or judge may also ask for a pre-sentence report to get more information about you. If this happens, you will not be sentenced until a probation office has completed this report and the traffic commissioner or judge had an opportunity to review it. The probation officer may interview you, your employer, or anyone else who can provide relevant information. This process may take a number of weeks. If you are sentenced to go to jail, you can ask to serve your sentence on weekends. In some circumstances, this request will be granted. So there are different types of fines. So any level of government, the city, the province, or the federal government has the right to impose a fine as a punishment for an offense. Each level of government has different ways to ensure that the fines are paid. We have city or municipal fines, which are imposed when you have violated a city bylaw, such as parking tickets and jaywalking tickets. These fines are paid to the City of Edmonton, and any court appearances will happen in provincial court. Then we have provincial fines, which are imposed when you have violated a provincial law, such as speeding tickets, public intoxication, and hunting and wildlife violations. Traffic violations are dealt with in traffic court, and others are dealt with in provincial court by the Crown Prosecutor. And then we have federal fines, which are imposed when you have violated a federal law, such as impaired driving, theft, assault, or any other criminal charge can result in a fine. In addition, many other federal statutes can impose fines, such as environmental statutes. These fines are dealt with in the criminal division of provincial court. So what is considered a minor offense? So we're now getting into the Bill 9 provisions. All provincial and municipal bylaw offenses, both traffic and non-traffic, so criminal as well, with a specified penalty of $1,000 or less, not including surcharge, committed on or after May 1st, 2017, must be charged using a Part 3 yellow offense notice, unless the peace officer thinks that it's in the public interest to issue a defendant a Part 2 pink summons. This can be without a voluntary payment option. If there is no voluntary payment option, court appearance is mandatory if you receive a Part 2 pink summons. According to Section 26, Sub 1 of the Provincial Offences Procedures Act, a peace officer can still opt for a voluntary payment when issuing a Part 2 offense. According to Section 27, Sub 3 of the Provincial Offences Procedures Act, try saying that 10 times really fast, the peace officer can waive any voluntary payment and compel a defendant to appear before a justice if it's in the public interest to do so. So it's really up to the police officer's discretion whether it is voluntary payment or court appearance. So what are your payment options? Go to the courthouse on or before your court date. Ask the judge to reduce the fine. The judge will consider the fine amount, your ability to pay, and the nature of the offense. You can also ask for more time to pay, and depending, the judge may also approve that. They may give you a payment plan so that you can pay in installments. And if a fine has default time, meaning failing to pay would result in jail time, then people have the option of going through the fine option program as well. The fine option program is available for people who don't have an income and are facing risk of jail time for non-payment. You must be at least 18 years of age and able to work in Canada to be eligible. It's an alternative measure, so you must plead guilty and it must be your first or second offense. You will be assigned work in community service projects. Hours of work will be between 8 a.m. and midnight any day of the week, and you will earn credits for hours you work at the legislated minimum wage. Maybe in lieu of or supplementary to another form of payment. So maybe you can afford to pay a portion of the fine, but not all of it. And so you don't have to choose one or the other. You can also do a combination. When you have had enough credits, a voucher is issued to the clerk of the court indicating that the fine has been paid. If you don't complete the program, would have to pay the outstanding debt, be given a fine, or you may have to serve jail time. To be eligible for the fine option program, the offender must be facing possible jail time for not paying their fine. Although Bill 9 has given the discretion to the court to curtail the risk of any imprisonment, so long as the risk is still there, the offender would qualify for the program. We also have something called e-tickets, which are roadside electronic traffic violation tickets, which enable police officers to scan driver's license information into a new online ticket template that auto-populates offense details. However, the e-tickets are not yet available in Alberta, but they are being currently used in other provinces. So what happens if you don't pay? Legal fines never go away unless you take action. In Alberta, the court sends overdue fines to registries. You will not be able to get services at a registry until you pay your fines in full. You won't be able to register your car, renew your license, or sell your car until your fines are paid. If you don't use Department of Motor Vehicle services, your property may be seized, or your wages, bank account, or tax returns may be garnished. If a civil judgment related to the fine or forfeiture has been registered against any of a deceased person's property, the executor of the estate of the deceased will need to contact fines enforcement to arrange for disposition of the debt. If there is no judgment registered, fines enforcement verifies that the debtor is deceased and the overdue fine and or forfeiture will be closed and all collection activity is ceased. So fines don't ever go away, even if you die. That's a scary thought. If your ticket does go to registries, for Part 3 fines, the court adds late payment fees of $20 or 20% of the ticket, whichever is greater. Registries will also charge a user fee to pay and an extra fee if you pay with a credit card, which is why when I have had tickets, I have insisted on going to the courthouse to pay it so that I'm not having to pay the additional registry user fees as well. It's bad enough that I'm paying the $20 or 20% of the ticket, whichever is greater. Or the smarter thing would be to just pay your fines on time. So how long until your services are restored? If you pay at registries, your services are immediately restored. If you pay at a courthouse, later that day, upon showing a registry agent your receipt from the courthouse, please hang on to your receipts, whether you are paying at registries or at the courthouse. It is really important that you hang on to your receipts until you know that those fines have been cleared from your account. If your income tax is garnished, it could take up to 60 days before your driving privileges are restored. If you have questions or concerns about your fine, you can contact the Fines Enforcement Program, and the address is there in Edmonton. Or you can, if you're calling from outside of the Edmonton area, you can contact Service Alberta 310-0000 and ask to talk to someone from the Fines Enforcement Program. And of course, they are available at your standard business hours from 8:15 to 4:30 and closed through the lunch hour. Not all overdue fines are linked to motor vehicle registration. You would have to contact the fines enforcement program to determine which fine or ticket you have outstanding. I would also like to mention that the only service at registries that is not affected by outstanding fines is if somebody is getting a provincial ID. So not a driver's license, but a provincial ID. They can still get one of those without having to pay all of their outstanding fines. And just a quick list of resources that people can access if they have any concerns or issues with tickets or bylaw tickets. Native Counseling has offices all across the province. You can contact Dial a Law in Calgary, or Student Legal Assistance in Calgary, or the Calgary Legal Guidance. And there's also student legal services in Edmonton as well. And so that concludes our information session, our webinar on traffic and bylaw violations, as well as the special considerations around Bill 9 and all fines up to $1,000 being automatically referred to registries as opposed to maybe going to warrant. So thanks for joining.